As I indicated earlier today, the Supreme Court has dismissed an injunction application which was seeking to halt the suspension of the Chief Justice, Justice Gertrude Torkornoo, by President John Dramani Mahama in a 3-2 majority decision. A 5-member panel of the court, presided over by the acting Chief Justice, Justice Paul Bafo-Boni, dismissed the application filed by the old Tafo Member of Parliament, Vincent Assafuah. Now, Justice Bafo-Boni, Emmanuel Yoni Kolendi, and Tanko Amadou were on the majority, while Justices Professor Henrietta Mensah-Bonsu and Ernest Gao dissented. Now, the court did not give full reasoning behind the decision, which is, it said, will be ready by May 21, which was some 15 days away from today. Earlier in the day, the Supreme Court dismissed an objection which was seeking the recusal of the acting Chief Justice, Justice Paul Bafo-Boni, from the panel hearing the injunction application against the suspension of the Chief Justice, Torkornoo. Now, in a unanimous decision, the 5-member panel of the court held that the objection had no merit, but some others think otherwise. In fact, Laud Adu Asare, is a legal affairs correspondent, was in court today. This particular objection, even though it was a unanimous decision, after the court hearing today, Godfrey Dami, the former AG, was also not too happy about it, is it not?
Yeah. So, Alfred, basically, the stance of the former Attorney General, who is the lawyer for the plaintiff in the matter, Tafo MP Vincent Assafuah, was that, so the two objections, right? The first one had to do with the acting Chief Justice, Justice Bafo-Boni, sitting as part of the panel of justices on the matter. Now, his argument was that for the administration of justice to be seemed to be exercised, and for the confidence of the public to be reinforced in the judiciary, the acting Chief Justice ought not to have been sitting on the case. Now, Alfred, we both know that Justice Bafo-Boni is acting as Chief Justice because he's the most senior justice at the apex courts at this point, over 17 years at the Supreme Court, and so automatically, per the provisions of the Constitution, he's supposed to assume the role of the acting Chief Justice, and that was the reason why I seated on it. So, Godfrey Damo was making the argument that he stands to gain if the Chief Justice, the tentative Chief Justice, Gertrude Torkornoo, is removed. He becomes the substantive, right? So it is not proper for him to sit on the case. But Deputy Attorney General, Dr. Justice Ansah, opposed this argument that he put forward, saying that the role being carried out by the acting Chief Justice Bafo-Boni is not one of benefit. He's not there because it's beneficial to him, but is one of duty. It's not like he has any choice anyway. He has to perform that duty because he's the most senior justice at the Supreme Court presently, and so that's why he's assumed the role, and so he has to empanel that. Afterwards, like you indicated, it was overruled, was dismissed. The second issue has to do with Dami again petitioning or objecting this time around the entire reconstitution of the 5-member panel of justices sitting on this matter. Now, Alfred, if you recall, since the case started, a different panel had been sitting, and this panel was chaired by Justice Professor Henrietta Mensah-Bonsu. The others included Justice Pramang, Justice Gaiwu, Samuel Sedu, who we now understand he's part of the committee investigating the petition against the Chief Justice.
So he's off.
He's off now. So if anything, perhaps we're expecting that maybe he would have recused himself, and so if anything, he would have been replaced. But we came today and realized that the entire panel had been reconstituted, with the exception of Justice Henrietta Mensah-Bonsu and then Ernest Gaiwu remaining. The 3 new additions now were the acting Chief Justice Bafo-Boni, Justice Emmanuel Yoni Kolendi, and then Justice Amadou Tanko. Now, Godfrey Dami's argument was that because the case had already begun, the old empaneled justices ought to have seen the entire hearing through. But the panel of justices chaired by the acting Chief Justice indicated that cannot be the case because the case, since its inception, had not really taken off per se. Because On the first day that the case was heard, it had to be adjourned indefinitely or sine die, because, and Alfred, you recall that on that particular day, Attorney General Dr. Dominic Aine sent a letter to the Chief Justice, who then informed all the judges across board that they were attending a symposium, and so he could not attend it.
Absolutely.
And that was why it was adjourned indefinitely. And the next time they were back in court was when we got to know that Samuel Isiud was absent, and so they were adjourned again to today.
True. So essentially, the case in itself had not been heard in detail.
Exactly.
Let's hear from Godfrey Yeboah. And I have two distinguished lawyers on the telephone to join this conversation. But take a listen to the former Attorney General, who is counsel to Old Tafo Member of Parliament Vincent Assafuah, earlier today.
I find it quite intriguing to start that the Acting Chief Justice himself will decide the proceedings, and as I indicated, I find it very progress. If at all there is any beneficiary from all of each government, and the Acting Chief Justice is a direct beneficiary of this. Of course, there's a constitutional injunction for him to act as the minister senior, but clearly we cannot lose sight of the fact that whatever has happened is meant for that question. And it's the Congress and the judiciary from this country. We've never seen any development like that before. Whenever there's a dispute as to the state of the Chief Justice in this country, start from 1980 for the Attorney General, start from 1983, 1984, Aban, and we go to 2005, thereabouts, the Chief Justice in question, and panel the court, but never sat on the matter. I mean, so it cannot be right for the Acting Chief Justice to say on the matter. But that's it. We see the 3-2 ruling, very narrow decision. Wait for the reasons. When the reasons come, we definitely advise ourselves. The narrowness of the decision itself indicates clearly that the application no doubt had merit and will know what to do. Right?
Your main argument, your final what is the timeline?
The reasons for the decision have not been known. Of course, clearly, I mean, the spirit of Article 146 we're talking about. In the first place, it is important to indicate that nowhere in Article 146 will you find the requirement for prima facie intervention made for Chief Justice. But the Supreme Court itself imported that into Article 146 in 2005 when it adjudicated on the Adjudication matter. But of course, the Supreme Court was silent on whether there ought to be notification to the Chief Justice and obtaining of his comment before triggering the process. And that is what is in this before the court. My contention is that natural justice, all the rules of constitutionalism and all will require that there ought to be such process before Article 146 can be triggered. Thank you very much.
Well, so that's Alfred Yeboah there. He is counsel to the Old Tafo Member of Parliament, Vincent Assafuah, and then also speaking to journalists after the hearing today. And Lord, stay with me, because I have lawyer Kwaku Ansah is former director of the Ghana School of Law, and also Christian Malm-Hesse is the private legal practitioner, constitutional lawyer as well. Gentlemen, I thank you so much for joining us on Hot Edition. Good evening to you.
Good evening, thank you.
Let me start off with you, Ansah, for good reason. I mean, some, including the applicant and his lawyer, as you just heard him, argue that to the extent that the outcome of the application somewhat benefits the acting Chief Justice, he should have recused himself from this case. There was a unanimous decision on that particular point. But then again, Godfrey Yeboah is convinced in his mind that precedence does not even support the acting AG being part of the panel for this case. Is there any merit in this?
No, not at all. There's no merit. The Constitution says that the Chief Justice shall be the head of the judiciary and has total administrative control, which includes the question of who to empanel. And the Constitution does not purport to exclude the head from speaking on cases and assuming jurisdiction as it were to hear a case. So the unanimous verdict of the 5 justices is correct in law. What my good son, Dr. Dami, is suggesting is that merely because the acting Chief Justice is in an acting position. If the petition for the CJ's removal enjoys success, then, he stands to benefit. I mean, it's neither here nor there. The president may decide to change his mind and go for another person. So, merely because he's in an acting position doesn't mean that, the president is constitutionally obliged, to vest on the position of Chief Justice of the Republic of Ghana. So, the argument is non-sequitur. It doesn't follow, as a matter of course at all. On the other hand, those who are saying that the acting Chief Justice has no administrative, mandate to empanel are getting it wrong, because as head of the judiciary, he can decide, to put A here and B there. Now, empaneling is not the same as assuming jurisdiction. So on the third day that the case was called, there was a panel, but we did not assume jurisdiction because of the letter the Attorney General had written to the court, notifying the court that the law officers might not be able to attend, the court that day, because they had been already firmly engaged elsewhere. So the court did not assume jurisdiction. There's a difference between empaneling and assumption of jurisdiction. So assumption of jurisdiction would then, confer legality on the proceedings of that day. So even though, they sat, they did not assume jurisdiction to commence, proceedings because of that letter. Now, if they had commenced proceedings, then those who are arguing that the panel ought not, to be right, because they had already they had already commenced proceedings. And one of the allegations against the incumbent Chief Justice is that he was interfering, in the judicial administration and administration of justice, by changing and transferring judges here and there. So the same argument would have been used against Baf Bonny. But that did not, arise, and therefore the question didn't arise, either. That's my, honest opinion on this matter.
I see.
Since they hadn't assumed jurisdiction, the acting Chief Justice was right, to reconstitute the panel. In any case, the element of fairness, could be questioned right from the moment the first panel, was constituted. Was it fair to have excluded, the first 5 most senior justices of the Supreme Court? If it was fair, fair enough. If it was not fair, then the acting Chief Justice has every right to bring back some of the seniors. Mind you, Justice Mahama, has been called to national number 2.
I think that I find it quite
in that order, and then so let us have the seniors. There's nothing wrong in having for back money.
We cannot lose sight of the fact that it's a cover.
In that order. There's nothing wrong with that.
We've never seen any movement like that before. Whenever this has to be the state of the Chief Justice in this country. Start from 1980, when I said start from 1993, 94, Japan, and 2005, thereabouts.
My good friend for Dr. Dami is suggesting that it was not fair for Babu Bonny to do what he did. But similarly, on October, let me just cast the nation's mind back to October 17, 18, and 20. When, objection was raised by Radio Story against Gao, the Chief Justice, her ladyship, Gertrude Torkornoo, that there was nothing wrong. And Gandhi was the Attorney General then, who had appeared before their lordships and saw nothing wrong. Why is he today complaining? If thou, who was, appointed from an MPP constituency onto the bench, was allowed to sit on an MPP case, I don't see why, the same party should now complain merely because the acting Chief Justice, is sitting on the case as one of the panel members. I think the argument, is flawed and shouldn't be entertained at all.
I see. And then looking at the details and how things played out, maybe we'll get into the ruling in a bit, but the reference was made to Georgina Wood. While a Chief Justice, she recused herself a number of times from cases, that she empaneled, essentially. So does that have any direct reference to what is happening now, especially because of the directive that the acting CJ, had given to empanel justice for all cases?
I don't think so. I think that the refusal of, one of Ghana's ablest lady Chief Justices, Georgina Wood, doesn't mean or provide presidential, value to the nation, not at all. I mean, when she went to Kenya as a Chief Justice, she passed. So maybe because of her cultural affinities and, challenges, she decided not to take, because if she starts, this is person who said that she was appointed by Kufuor while she's sitting on. So maybe she decided that she said something within her that suggested to her that she should not take, and she didn't take. That doesn't mean that other Chief Justices must necessarily toe that line. It has no presidential value. The Constitution says in Article 125.3 that the Chief Justice shall be the head of the judiciary, shall be the head. And as the head, she has the most say in every matter. Now, this issue of empaneling is something, that has, been a perennial issue. It's been going on since Nkrumah's days. And I remember in the 90s, Justice D.N.K. Taylor, brought an application for consideration of justices of the Supreme Court. At that time, Chief Justice Showa, was the head of the judiciary. And all the justices felt that, according to the doctrine of necessity, they should not, do anything about that, the provision that allows the Chief Justice as the administrative head to empanel. So if you look at the other decided cases, Bright Akwete, J. Tom, and the others, it was the Chief Justice who empaneled. And in Ghana Bar Association versus Chief Justice Aban, a strong Supreme Court decided that it is the constitutional duty of the Chief Justice, whether substantive or in an acting capacity, to empanel. They could do nothing about it, and that Ghanaians must have confidence in the head of the judiciary to do what is right, and not always to read meanings into what the Chief Justice will do, or as to whether the Chief Justice will include this person or exclude that person.
Well, and talking about reading meanings,
that the Chief Justice will do the right thing.
Right, and talking about reading meanings, already the ruling and those who opposed has also, for some, sent certain signals, because this decision that was delivered today saw Justices Henrietta Mensah Bonsu and Esgaiwo dissenting, essentially. And they were the ones who were part of the panel that started hearing this case. Those who, based on this decision today, supported and in fact gave that majority decision was Justice Paul Bafoboni, the Chief Justice, acting, and then also Justice Yoni Kolendi and Justice Amadou Tanko. These three were the ones who were added to the reconstituted panel. What signal does this send you?
Well, it's one of guesswork. It's not going to be based, on law. That because signals, are not, informed, by what the law says. The law is in the bosom of the judges. One, they are saying that there's nothing wrong. All five of them, there's nothing wrong, in including or adding the acting CJ as part of them. There's nothing wrong. Now, if they say their contention is that there's nothing wrong with it, then the signal to the nation is that let's have confidence, in the judiciary. They will deliver in accordance with the law, in accordance with what the law says. And mind you, Chief Justice Torkornoo has always explained that the Supreme Court, when they say all that they do is based on what the law says. So whether they were empaneled by the incumbent Chief Justice, or let's say the suspended Chief Justice, or the acting Chief Justice, what they are, the signal to the nation is that we control the law. The law is in our bosom, and on this occasion we are split. So there's division, in our opinion as to the verdict that we are going to deliver. So three felt that the process should not be altered. Two felt it should be altered. Personally, I think that the president would rather be contravening the law if he should halt the process. The president may lift, doesn't mean the president should lift the suspension. I mean, it would be absurd for the president to receive the petition, go through the consecutive stages, forward it to the Council of State, full consultation with the Council of State, agree that there's a prima facie case, set up a committee, suspend the Chief Justice in order to allow the committee to do its work to completion, and then all of a sudden, would decide to halt it. On what basis? It must be informed in law. It must be informed in law. And, I personally, think that we should allow the process, to work to the end. Let the process work. Let us see the outcome. Let the doubting Thomases have their day. Let those, petitioners have their day. At the end of the day, the president has made it quite clear. And the Supreme Court has also added his voice. The suspension is not an acknowledgement or admission of guilt on the part of leadership Chief Justice Torkornoo. Not at all. Well, all it means is the Constitution says that if a committee is established, then it means, as a necessary consequence, the Chief Justice shall be suspended. It is not the president who is suspended. It is the language of the Constitution that has been implemented. That is all.
For you, even before this case started, you said it was dead on arrival. I mean, for the applicants, to the extent that for them, to the applicants, they say that to the extent that 2 out of the 5 justices who sat on this case agree with them, it cannot be the case that this is a case that was dead on arrival.
Oh, for me, it will remain, dead on arrival, to eternity, because, in the reasonable contemplation of the framers of the Constitution, the process could be halted, then the Constitution, would have created room for that. And, the Rules Committee would then, act on a particular provision to say that where a citizen or a person is aggrieved, that person can avail himself or herself of Article 2(1) of the Constitution, then we'll have, a very strong case for that. But it is not for nothing that Article 2 has created room for any person who is aggrieved, that the Constitution is being strangulated, to go to court. So when you feel aggrieved that something is being done which is unconstitutional, can go to court. But on this Article 146, there's no such room for Article 2. Okay, so no one can invoke the Supreme Court, to like this instant application to hold the process. It is unconstitutional.
I thank you so much, sir. Thank you so much for your time on this matter, and I know we're going to be engaging some more as we go on. Appreciate you. And there you just heard the former director of the Ghana School of Law there talking to us, and Kwaku Asare. Let me Christian Malm-Hesse is also private legal practitioner, has been listening every step of the way. Now, I want to bring you in briefly on this particular outcome today, and whether or not there is any merit in that concern raised by the applicants in this particular injunction. Well, that has been thrown out now, to the extent that, in their view, 1, 2 out of the 5 justices agree with them. They're going to review the full details of the reasoning, and then they'll take the next step. And then also the fact that, in their view, the acting Chief Justice should have recused himself in this particular case. I want to find out your thoughts on this.
Okay, all right. So thank you for having me. In a way, I mean, the issue about the Chief Justice recusing himself in matters of this nature, it has been decided by a lot of cases. You look at the Ghana Bar Association versus Attorney General, where Martin A.B. Amedu was then the Deputy Attorney General who was the applicant, and you have Joseph Kwasi-Aiden as the respondent sometime in 1996 that sought to challenge Justice Isaac Kobina-Aban to such a situation. And the court in its decision indicated explicitly that, the judicial independence is protected and cannot be undermined by any such external action, such as attempting to prevent the Chief Justice from sitting or empaneling the court. And the court further went on to emphasize that the Constitution establishes judicial independence, and any attempt by that to be seen as interfering with the Chief Justice's constitutional function, and that is unconstitutional. The interesting thing is that if you further look at this case of Kunia and others versus Acha and Co., and we had a very star-studded panel at the Supreme Court, led by Justice Adade, and then followed by Francois, whose judgment is mostly indicated as one of prose in literary form. And you had Amwatichi, Akins, Edward Reid, Bamford Ado, and Efron Benjamin. And they also had the opportunity in Kuniya to say that the Chief Justice has the constitutional role, including presiding over courts and also empaneling judicial proceedings, and that no attempt by a litigant would cause this function to be deferred. And the most, or let me say, the local classical case in this particular one has to do with what you call it, Akufo-Addo and Kwasi-Aiden in 1968. And in this situation, again, when the Chief Justice was being hounded not to empanel or to sit, again, the court had the opportunity to deal with this. And the court, again, in the Chachuchi Kata versus Chief Justice and Attorney General, referred and quoted these cases that I had mentioned to you with approval, that the Chief Justice has a role to play as far as Article 125 and Article 128. Article 128 deals with the functions of the Chief Justice, which deals with empaneling. Whether the Chief Justice is part, which is at his discretion, or the Chief Justice will put the members of the Supreme Court together to have that quorum of 5.
Right.
And that no attempt by any litigant they would yield to it. And he went on to say that if that happens, means that the Chief Justice will be ceding to the maneuvers of a litigant. And that those were the phrases that were used. These are areas of law that has been litigated,
already dealt with.
Has been given over and over, and it is nothing new. That's why there was a unanimous decision.
It's a very important point you make, and then the precedents you reference as well. And I do thank you so much.
Maybe we'll talk more about this.
Certainly, I agree perfectly with you on this. Christian Malm-Hesse is private legal practitioner. So, Lord, what next after today? Quickly.
Well, it just means that the work of the committee, there will be no impediments. They're now going to proceed, and then once they are done with the investigations, we'll know the outcome of what they came up with regarding the petition against the Chief Justice Gertrude Torkornoo.
I appreciate you.